counsel for this morning, so we have 4 remaining cases, and they'll be heard in the order in which they appear on the calendar that you've been provided. After the second case, we'll take about a 15-minute recess, and there should be coffee available in the Commons, and if you'd like, we ask you to join us over there for coffee at that time. We'll hear Coretta Jones versus Tallahassee Memorial Regional Health Care.
May it please the Court, Maria Sperando, Gary Williamson-Parenti, on behalf of the plaintiff appellant, Carisha Jones. We ask that this Court, and I'd like to reserve 7 minutes for rebuttal, please. Thank you. We ask that this Court reverse the trial court's grant of summary judgment for 2 reasons. First, and I'm going to put this on track A, the trial court erred in holding that as a matter of law, there were no genuine issues of material fact in dispute as to 3 issues. 1, apparent agency, the apparent agency of the anesthesiologist and the nurse anesthetist. 2, actual agency of the anesthesiologist and the nurse anesthetist with regard to the hospital. And 3, the hospital's own employees as to their own direct negligence. So I'm calling that track A. We maintain...
Okay, are you giving up the argument on illegal, on non-delegation?
No, sir, that's track B. That's track B because I moved for partial summary judgment and said that as a matter of law, the hospital has a non-delegable duty with regard to the negligence of both the nurses, the nurse anesthetist, and the anesthesiologist.
Excuse me, but I've laryngitis, but I need to ask you a question. On the non-delegation doctrine, the trial court ruled that you couldn't file your second amended complaint because it was outside the statute of limitations and did not relate back. Nowhere in your brief do I see where you challenge that ruling. And if you do not challenge that ruling, how do we even get to the illegal delegation doctrine question?
Okay. Two reasons. Number 1, the trial court ultimately did rule on the issue and did decide that it was in play.
I understand he ruled on it, but he also said in a footnote that he was going to rule on it, but it didn't reverse his earlier ruling that you couldn't amend the complaint.
Okay. With regard to the amendment of the complaint, all he said was, with regard to when I amended the complaint as to non-delegable duty, he just talked about, and I mentioned that in the first part of my brief, he just talked about the first question. The trial court denied the motion as to the vicarious liability count based on the hospital's participation in the Medicare program. The court finds that this claim, the Medicare program claim, is in essence a claim for strict liability and is a new cause of action which does not relate back to the filing of the original complaint and therefore was time barred. The court did not address the issue of non-delegable duty as it pertained to a duty created by Florida law, by contract, or by the inherently dangerous nature of providing anesthesia, number 1. Number 2, I didn't even have to move to amend, Your Honor, because in the original complaint, it alleged there was a count for vicarious liability. And as this court made clear in Shands versus Juliana, non-delegable duty is a form of vicarious liability.
Did your original complaint even mention the terms non-delegable duty?
The original complaint I do not believe did. Okay. But it mentioned vicarious liability. If the court would read the case in Juliana, non-delegable duty is simply a form of vicarious liability because there the hospital or the entity is not actively negligent, but rather has a duty imposed by law for the responsibility of whatever the tortfeasor did. So it is a form of vicarious liability that that was in the original complaint, didn't even have to amend to allege.
Okay. On the question of the Juliana case, Judge Benton in that case said that nobody would know that they were contracting separately with the man that ran the machine in that case. There was no agreement or any relationship between the patient and the person that they said basically that there was a non-delegable duty to. Here, your client signed let me see what it's called. A patient's consent form for anesthesia procedure, which said that it would be conducted by Anesthesiology Associates of Tallahassee. Why is that not a waiver? If there was a non-delegable duty, why, when your client signed that, is that not a waiver of the non-delegable duty?
For two reasons. Number one, we're talking about a nurse. A nurse, there are two separate,
Talk about them separately. The doctor first and the nurse, because you're calling both.
You want the doctor first?
Yeah.
Okay. If you look at the, I wish I could find it because I have a sticky. I thought I did. There is an officer and a gentleman. Thank you. If you look at the patient's consent for anesthesia, all it says is, I consent to anesthesia care and procedures being provided by or under the medical direction of an anesthesiologist of Anesthesiology Associates of Tallahassee or his associate. So, number one, it does not talk about, we don't even know who Anesthesiology Associates of Tallahassee is. It does not state the employer status or the employment status of the anesthesiologist, of Anesthesiology Associates of Tallahassee, of the anesthesia care team, or of the certified registered nurse anesthetist. And I make that point because in the pamphlet, the provision of doctor's care pamphlet, the hospital specifically states the following 5 specialists are not employees of the hospital. One of those specialists is an anesthesiologist. So we're not talking about who is going to be providing the service. We're talking about who is responsible for the service. For example, today you have an emergency department physicians at this very hospital. They are employees of the group is employed by the hospital, but the group provides the service, and yet it is the hospital that is responsible.
That kind of goes to another question, and I'll let you get to the nurse in a second, but your apparent authority argument. In the cases where apparent authority has been found, it's usually whether it's billing done by the hospital or the people actually have an office in the hospital and don't have separate offices. The emergency room physicians that you're talking about here, did they have a separate office outside the hospital?
Did the anesthesiologist have?
I know the anesthesiologist did, but you just
I don't know
mentioned...
the answer to that, Your Honor. I do not know.
Okay.
I don't know if the group who is there today has a separate office outside the hospital. I don't know that. But let me make it clear that if you read this, you don't know who the employer is. And I'm talking about someone such as Mrs. Mosley with a limited education, a patient goes in. If you read this, how are you going to know that even though all of the healthcare services in a hospital are provided by someone. The emergency department nurse provides a service, and yet she is employed by the hospital. Where does it say that any of these entities is employed by the hospital? And certainly if the hospital wanted to deny liability or make it clear to your average patient, hey, we are not responsible. They knew how to do it because they did it in the About Your Physician Care pamphlet. And moreover, it does not mention anything about nurse anesthetists. And I think it's important to note that the hospital itself employs 2 nurse anesthetists and uses this very form.
Counselor, what's the status of the pamphlet? Did your client get a copy of it, or just where are we in the status of proof?
The record is bare with regard to that, Your Honor. The only thing that is in the record is that it says there was testimony that it is the routine of the hospital to give it out.
Right. What is the legal effect of it being the normal routine of the hospital to give out this pamphlet?
It only provides an inference, not a rebuttable presumption that in fact she was given this form.
Okay, the inference. Wasn't the trial court admitted, since he can assume this is an inference, couldn't he assume that and take that as an inference for the purpose of entering this summary judgment?
Absolutely not, Your Honor. It creates a question of fact. It goes to the jury. It's just an inference. That's all it is. It's not a rebuttable presumption. I would agree with the court if it were a rebuttable presumption. It's just an inference. But more importantly, it says absolutely nothing about the nurse anesthetist. And I think that under the rule, if you mention 5 physicians, 5 specialists, and you mention an anesthesiologist, and you don't mention the nurse anesthetist, then you can assume that the nurse anesthetist is not covered by that. In other words, if the anesthesiologist, if they're taking the time and the effort to point out these 5 specialists are not employees, are not employees of the hospital, but they don't mention the nurse anesthetist, then the patient is not on notice that the nurse anesthetist is not an employee. And I submit to the court that when you come to a hospital and you get treated by a nurse, that you believe that that nurse is employed by the hospital. And that, in fact, is Florida law. Nurses are employed by, or hospitals have responsibility for nurses. So under the non-delegable duty, they are dead in the water. Shands versus Juliana specifically holds the perfusionist, that the hospital there was responsible for the liability of the perfusionist. And the court said, you do not have to go to a parent agency law in the case of a perfusionist anymore.
In that case, there was no consent signed as in this particular case.
Consent for anesthesia services, Your Honor?
Right. For the perfusionist in that case.
Yeah, but there was no, Your Honor, respectfully, you can look in this record 24/7. You're not going to find any consent to be treated by the nurse anesthetist. There is nothing that mentions.
Well, even there's at least an implication because it talks about a team that will be providing anesthesia services. And it says that anesthesia services and care will be provided by Anesthesiology Associates of Tallahassee. And then it talks about a team.
Yes, Your Honor. And it does not say anything about who employs the anesthesia care team. Absolutely nothing. And I submit to the court that it is on, the burden is on the defendant, the hospital, to make it clear to a person of average intelligence when you read this that, oh, the nurse anesthetist, the nurse, is not employed by the hospital, the hospital is not responsible for the nurse anesthetist. And this does not make that clear at all.
Okay, can I switch with you? Because you're down to about three minutes and 45 seconds. The apparent authority. What actions did Tallahassee Hospital take here to demonstrate or to hold these people out as having apparent authority?
Number one, advertise their services on the website, Your Honor. Didn't say that they were not employees. Number two, they had badges which said TMH. Number three, they were provided by the hospital when the patient walked in. They were not told beforehand, oh, as with a surgeon, you have to pick your own anesthesiologist. Number four, they were not given a choice. They were not even told, you can have Dr. Smith or Dr. Jones. No. Dr. Smith showed up, you were stuck with him.
Okay, but there are cases out there that say merely having people on staff does not rise to apparent authority. It seems like the badges, they were provided, not given a choice, that always tends to go with having a doctor on staff. How is this different than just having a doctor on staff?
Absolutely. This is totally and completely different. That's what they keep saying. Having a doctor on staff, they advertised, they gave them badges, they provided them. You don't provide a pediatrician. You don't provide, as in this case, the surgeon was not provided. She chose her own surgeon. Moreover, in this particular case, the hospital dictated to the anesthesiologist and the nurse anesthetist much of what they did. Moreover, the group here, Anesthesiology Associates of Tallahassee, they chose and always choose the chairman of the anesthesiology department, and it always comes from their group. So in this case, the relationship of the anesthesiologist and the patient is far different and far more complex than simply privileges. And I'll tell you this much. This hospital could not function without Anesthesiology Associates of Tallahassee. There are about 18,000 services of anesthesia that are provided every year, and they provide about 99% of them. So it's not like, well, there's a pediatrician who has privileges and he may practice and he may not. This particular group is essential to the functioning of this particular hospital. This is not simply, we're not simply talking about privileges. We're talking about an integral part of this institution where when the patient comes in, she thinks that this anesthesiologist who's provided to her is a part of the hospital. And Your Honor, I'd like to, if I may, just leave the rest for rebuttal.
Thank you.
May it please the court, Jesse Silver on behalf of the hospital. Thank you very much. I just wanted to, let's not start out by getting the cart before the horse here. The law in Florida is crystal clear that the fact that a physician may have staff privileges with a hospital is not the basis for liability. That's the law. The undisputed evidence in the case from Dr. Jack McDonald, who's the chairman of the medical staff, was that the only relationship between this very group and the hospital was the fact that they had staff privileges. Now, there's no secret about...
Well, Mr. Super,
Yes.
isn't there a gulf of difference between a physician and an anesthesiologist, as opposing counsel has pointed out? You pick your physician. Did this client or this patient have a meaningful choice as to the anesthesiologist that she would select?
Judge, I will concede to you that she didn't really have a meaningful choice because, you know why? They're the only group in town. But the fact that they're the only group in town does not create a holding out by the hospital, which is the first critical element of creating an agency relationship. Because if you use that analogy, let's think if you go back down to Madison or Perry or some of these other small hospitals, they can't recruit anesthesia groups, so they don't have anybody. Here, we have the luxury of having only 2 hospitals and a great big group. But to follow that line of reasoning, every small hospital that has only one group is automatically responsible for that anesthesiologist's actions just because they don't have any choice. And if you look at the Mobil Oil case and you look at the way business interests are in the healthcare field now, that's just the way it is. We can't guarantee choice of anesthesiologists all over. For example, if you're down in Miami, you might have 15 hospitals and 5 or 6 groups.
Does that constitute the fact that you can't provide anybody else? Does that provide a legal exception to the apparent authority doctrine? I know it's a problem. I mean,
well, respectfully, Judge, I think if you look at the apparent agency doctrine, you don't even get to that issue about choice at all unless and until the plaintiff has put on evidence that, number one, there was a holding out by the hospital that the anesthesia group was acting on their behalf. That's under the Supreme Court of Mobil.
That gets to me to where I have a little concern. The website and the advertisement. Talk to me about that.
All right. First of all, there's no showing that website was even in operation in 1996. Secondly, there's no advertisement whatsoever. All there is a list of the doctors who have medical staff privileges. As we said before, the law is clear that staff privileges do not confer liability just on that basis alone. Now, in the De Silva case, which is the only case that we've seen here, Cedars-Sinai versus De Silva, in that case, which dealt with the anesthesia group, the hospital went out and advertised the services of the anesthesia group and provided the patients with brochures and did all these other things that y'all were talking about earlier about controlling the workplace. What's critical to understand here is the first thing you have to start from the beginning. The beginning principle is there's no liability. With a parent agency, there has to be a holding out, accorded by the Supreme Court. The undisputed evidence here is there's not any holding out at all that they were acting on our behalf. Now,
well, Mr. Stuber, how about the name tag?
Yes, sir. That's a perfect.
That's holding them out somewhat to be an employee or something with TMH.
It is exactly that. It shows that they have medical staff privileges. Let me point out.
It state that on the name tag that they had. They were medical staff privileges.
It says TMH medical staff is what I believe. The point is, Judge, that is an indicia of medical staff privileges. The hospital's got to have some control. They're required to by some of these statutes. That is not the fact that they have got to provide ensure the provision of anesthesia services, operating rooms, all those kind of things does not make the hospital responsible for everybody who's providing the service. With respect to the name tag, the hospital has all kinds of requirements on doctors who are in their medical staff, like if you're a surgeon, you're going to take ER call. They've got to do that. Similarly, if you're going to be in my hospital for safety concerns and everything else, you're going to wear a name tag. That's not the same thing as holding them out as being responsible for the anesthesia.
Mr. Stuber, couldn't you make that argument to a jury and a jury disagree with that? For example, here we have externs from the university. They get a name tag, come in here, and it says extern on there, so we know that they're not an employee. Or you go over to the Capitol and you get a sign that says visitor. So why couldn't the jury just say, well, I don't think that that's so insignificant, and rule in favor of the claimant?
Well, first of all, Judge, it should not get to the jury because, first of all, they've not made an allegation or any evidence at all that we held those people out or those interns out as acting on our behalf. Secondly, the case law is clear that the subjective understanding of the patient has nothing to do with the creation of an agency relationship.
Well, isn't that a fiction anyway, though? Because you look at the cases, and they say acting on behalf. And they say, well, if you bill together, that somehow holds out that this person, you're responsible for this person. I mean, is a lay person getting that bill really going to understand?
Again, Judge, the subjective interpretation makes no difference at all. If you look at the Izquierdo case, that case, the patient goes to the hospital and she's looking for a pediatrician for her kid. The hospital provides the pediatrician through their health care plan. The court held in that case that there's no creation of a parent agency. Why? Because the expectations of the patient cannot create agency, nor can the...
But that expectation is based on the reasonable person theory, isn't it? If a reasonable person would take that, you can't just go in and say, well, I thought it, when a reasonable person wouldn't. And that's the standard the jury would apply, Mr. Sue.
Judge, no, sir. Respectfully, it's not, because you don't get at all to the jury question here, because the law is very clear that the subjective understanding of the patient, whether they got the brochure that told them that anesthesiologists don't work for the hospital or not, is irrelevant.
All right, let me talk to you. Oh, you say the brochure is irrelevant.
No, sir. What I said, whether she herself personally received it is irrelevant. Here's why that is relevant. Because to create an agency relationship, the very first element, according to the Supreme Court, is you've got to show that they were holding the anesthesiologist out as acting on their behalf. If at the same time there's not that relationship, at the same time you're distributing a pamphlet to every single patient that says the exact opposite, they are not acting on our behalf, then you can't get to that first element on the agency claim. And I'll direct your attention to the Ressler versus Novak case and Judge Altenberg's dissent, where he cites a Kentucky case that specifically says in Kentucky you cannot have an ostensible agency relationship if you disclaim it, whether the person gets it or not, because it goes directly to the mindset of the principal. If the principal cannot be holding them out as acting on their behalf, and at the same time saying we disclaim any responsibility.
Okay, let's move to the non-delegation.
Yes, sir.
In Judge Benton's case, it's Shands.
Right.
It seems to me you have a good argument as far as the doctor here, because this person signed a patient consent form with anesthesiology associates. But following Judge Benton's reasoning in Shands, he said, well, people that go into a hospital assume that nurses and technicians and those kind of people are going to be employees of the hospital.
Right.
Doesn't that case cause you a problem if we get to the delegation question?
No, sir. In fact, the Giuliana case helps us. The Giuliana case acknowledges that there's let me just read you, that differentiates between traditional hospital services and physician services. You can call the CRNA a nurse all day long. And I would agree with you that, well, before I get into that, the provision of anesthesia service is not a nursing service. It's a medical service. It's traditionally been provided by physicians, not by nurses. So you can call this person a nurse, but you have to look at what they're doing. And what they're doing is providing medical services in the form of anesthesia. The Giuliana case distinguishes between those services traditionally provided by physicians and independent contractor physicians and those that the hospital normally provides, like nursing services. This is what they say. This is what we said, y'all said. The present case differs importantly from cases in which physicians, as opposed to nurses or technologists, have established independent contractor relationships with the hospitals. They then cite the Supreme Court in Valcine for the principle you mentioned earlier, Judge Wolf, which is that staff privileges don't confer liability. And then they say this is because patients normally contract separately for physician services, but do not normally contract separately for services of hospital-based nurses and technologists. And in this case, that's exactly what she did. She went to the hospital not on the day of surgery, 2 days previously, not because she was expecting to get anesthesia, or she didn't come to the hospital to get put to sleep. She came to the hospital for elective surgery by her physician, sat down with her anesthesiologist who gave her this form that Judge Wolf referred to, where she says, I consent to anesthesia care being provided by anesthesiology associates of Tallahassee. And again, I'd point out in that paragraph they say, the anesthesia care may be provided by an anesthesia care team, which will include the anesthesiologist and one or more certified registered nurse anesthetists. So 2 days before you even get into that issue of the surgery itself, she has agreed that AAT, not TMH, is going to be providing her medical services.
Mr. Super, this point earlier in this argument, not in yours, but opposing counsel.
Yes.
I ask is it ATT?
AAT, yes, sir.
AAT. Did they have an office separate from the hospital?
Yes,
Is that in the record?
It is in the record. They have an office where they do pain management. They also service all kinds of, they're the only group around, so they service the whole region, all the hospitals.
And this appellate, did she go to the office of the anesthesiologist or to the hospital to meet?
You know, I don't really remember. I think she went to the hospital. But the point is, see, here's what normally happens, all right? The Irving case started it all off, and the court in that case held that the patient's going to the emergency room of this hospital. Hospitals traditionally provide emergency services. So it's a non-delegable duty, and you can't contract that away unless you tell the patient, okay? That's because you're going to the hospital to get emergency medical services. People don't go to hospitals to get put to sleep. They don't do it. They go to the hospital to get an operation, and incidentally, they get put to sleep. So the issue's not even analogous from my standpoint. I wanted to mention very briefly that from a public policy standpoint, the plaintiffs are arguing that every hospital in the state should be vicariously responsible for every anesthesiologist. I don't understand the public policy for that. I mean, like Juliana said, patients have traditionally contracted separately with physicians. That's the way it's always been. There's no reason for changing that. I'd point out briefly, too, that they talk about the state and federal regulations that require...
Sure, let
Yes,
me
sir.
ask you about the pamphlet before you go there.
Sure.
Wouldn't it have been real clean and easy for your client to have had this patient sign that brochure that has the disclaimer for all these people, rather than we're sitting up here, we might have given it, we usually do it, but nobody knows whether it was done or not?
Well,
we wouldn't, there'd be no question about this if you had a signed document like many people have on these type of things.
Judge, I don't dispute that it would have. But what I'm trying to get across is the critical issue here is unless the hospital did something to hold that person out, then it doesn't make any difference whether they got it or not. The point is, as Judge Altenburn cited in his dissenting and concurring opinion, I think it was, you can't do both of those things and be consistent. Dr. McDonald's affidavit and deposition is the only evidence in the case on that, and he's pretty clear directly that we never held them out. And if we never held them out, it's consistent with us to distribute to everybody else, telling them the fact that they do not work for us and they're not our agents or employees. So, I mean, it's very consistent. If you look at the Mobile Oil case, which is the Supreme Court's dealt with this specifically, that they've no evidence put on by the plaintiffs to get to first base on the apparent agency thing. And I want to point out, like the Izquierdo case says, you can't create an agency relationship by something that's told to you by the purported agent or by the subjective beliefs of the plaintiffs. In the Manderville case, which this court heard back in 2000, in that case, the facts were exactly the same. In terms of the pertinent agency relationships, it was the same group, the same hospital. In that case, the anesthesiologist from AAT testified that he told the patient, I'm the anesthesiologist from the hospital. And in that case, this court affirmed summary judgment in favor of the hospital on the apparent agency issue. Why? Because they never got to first base and showed that the hospital ever held them out as their agents. And moreover, that they had disclaimed it. And moreover, and more importantly, in the Izquierdo case, the purported agent cannot create an agency relationship. Only the hospital can do that. Now, I just want to briefly, if you have any questions about those regulations, my point that is, the regulations obviously require a hospital to have anesthesia services available. That does not create a non-delegable duty. The Villazon case, the Florida Supreme Court case, addressed that issue, I think it was in 2003, and said that in a statute that's passed generally for the public good and public benefit, it does not create a private right of action unless it specifically says so. These statutes have been around forever. No case has ever held that. Let me just see if there's anything else I wanted to address. Again, I understand that it's very confusing when you're talking about what a patient may have understood about the anesthesia services that were provided. But I want to point out to you that you don't get to that analysis unless you've first satisfied the holding out argument. Traditionally what happens is you can only create a parent agency, as I know it, by two ways. Number one, the holding out theory that we talked about, that the Supreme Court talked about, Or number two, when it all first started out, that was in the ER context. And what happened in that setting, and it's laid out very clearly in the brief, is the hospital tried to make an independent contractor defense, and the court allowed the apparent agency exception. So it's only if you got that contractual relationship, which we don't have, that you even get into that analysis. Yes, sir.
Whose equipment is that the anesthesiologist uses in the surgical room?
They use TMH equipment as the surgeons use TMH scalpels and TMH ORs and all that. Thank you very much, Your Honors.
I want to make it clear to the court, there are two agency issues here. Number one, apparent agency, and number two, actual agency. Although the hospital says over and over that there was no contract here, there was a contract in everything but writing. There was no contract because they say, we're not going to have a contract, are we, fellas? But all of the indicia of contract was there. It was an implied contract. These people were actual agents of this hospital. That's number one. Number two, with regard to the non-delegable duty and the nurse, there is no way out for the hospital on this issue. If the court would look at my reply brief, page 8, footnote 15, if you compare the function of a perfusionist with the function of a nurse anesthetist, they are almost identical. Part of the perfusionist job is regulating the proper oxygen and carbon dioxide content and the proper acid-base ratio in the blood, et cetera, et cetera. That is precisely, well, I should say, that is very similar to what a nurse anesthetist does. So in terms of function, this court ruled that a perfusionist was a traditional duty that the hospital had contracted for. There is no way out of a non-delegable duty with regard to the nursing issue. With regard to non-delegable duty, again, I'd also like to mention the inherently dangerous basis for holding the hospital liable. Both the hospital and the trial...
Has anybody in Florida declared providing health care to be a dangerous instrumentality?
I'm sorry, say again, Your Honor?
Have you have any support in Florida for that theory?
There is no case law. However, if the trial court and the defendant have both admitted that this is an inherently dangerous activity, the case law in Florida says inherently dangerous activities, whatever they are, may not be delegated.
Thank you very much, counsel. Next case on our calendar is Florida.